of the media. We are basically here. Last time we had a press conference, I hinted you, the media, that we will continue to review the outcomes of judicial proceedings regarding the 2023 election with a lot of litigation, a lot of cases that are in court, and we have come again today to do one more about the attempt by some election petition tribunals to rubbish some institutions. This press conference, I don't know where, there is another group that has joined us for this conference, but the members are not even, the representative, about 2 of them are not here. They're supposed to be here, maybe they're on their way. So this is a press conference statement by Human Rights Writers Association of Nigeria in conjunction with patriotic defenders of national institutions. We are constrained once more to address the media on the particular judgment that was rendered in the governorship election petition that came up in Enugu State. Enugu State is a major flashpoint in the sense that it's almost same thing with the contention that is going on about identity theft, the alleged identity theft that involves the number one citizen of the country, because it's also something that dovetails into allegations of certificate forgery, and the fact that the tribunal jettisoned that fundamental question and didn't even bother to treat it, which goes contrary to the expectations of millions of Nigerians. So I'm going to read the statement straight away, so that I wouldn't want to not hit the nail on the head, so that it is not left for the media to interpret it the way they want. But we, the Human Rights Writers Association of Nigeria, in conjunction with the patriotic defenders of national institutions, were here gathered to address a matter of utmost importance to the foundation of the nation's democracy. We are deeply concerned about the recent judgments handed down by the Enugu State Governorship Election Petition Tribunal regarding petition number EPT/EN/GOV01/2023. When we finished this press conference, I actually forgot to get, there are copies of some documents that I'm supposed to give to the media representatives here, but I was so much in a hurry to start the press conference exactly 1 o'clock, I forgot it in the car, So when we finish, I'm going to give you copies of those documents that we obtained from the court. We are deeply concerned by the judgment, as I said. The petition in question is the one that is filed by the Labour Party candidate in Enugu State, Honorable Chijoke Edoga, the Labour Party, which challenged the result that was released by the Independent National Electoral Commission that stated that the PDP candidate emerged the winner. The case brings to light crucial issues surrounding the integrity of certification, justice, and the rule of law in Nigeria. This is why we are emphasizing so much on this matter, because it is not just about ordinary election. It's not a contest between just 2 people. If that is the case, we will say, what is our own problem? We're not bothered about it. After all, it's politicians. Let them fight it out. But it's not about politicians, it's not about public office holders, but it's about the integrity of our judicial system and the integrity of the justice sector, justice delivery system in Nigeria. So I continue. I want to give the media what we consider to be the key issues, in as much as some of you must have been made aware of it. The governorship election in Enugu decision raised serious questions about the conduct of the tribunal, the credibility of our institutions. Again, we are harping on the attempt to rubbish major national institutions like the NYSC, the DSS, and the Judiciary itself. We will explain as we go on. The implication also borders on the question of certification standards and process in Nigeria. The tribunal swiftly dismissed allegations of NYSC certificate forgery against the PDP candidate, Mr. Peter Mbar, and rejected the how's this going to print this out? And rejected the Labour Party's claims of overvoting and bypassing the biometric voter accreditation system, or what they call BVAS. The tribunal's conclusion, as we know, returned P2B as the winner. However, the Labour Party and its gubernatorial candidates are already appealing the decision. The case before the tribunal that was led by Honorable Justice Kudirat Akano points to a clear instance of electoral malpractice or overvoting. The petitioners presented evidence that after the collation of 16 out of the 17 local government areas in Enugu State, the petitioner was of the claim that he was in the lead. But shockingly, the PDP Enugu, with every likelihood, with the involvement, conspiracy of INEC, awarded the PDP a staggering 30,000 votes. These are some of the issues that came up during the tribunal hearing. The Labour Party alleged that the INEC BVAS data for Nkanu East showed a total of 15,000 accredited voters on election day. However, the PDP was awarded a staggering 30,000 votes in the local government area, and the Labour Party alleged that the INEC BVAS data from Kano East LGA showed a total of 15,000 accredited voters on election day. However, when the results were declared, the PDP was credited with a total of 30,350 votes, while the Labour Party received only 1,855 votes. How could INEC report over 33,000 votes in a location where only about 15,000 voters were accredited? Legal experts who are members of our organizations have analyzed the judgment and found it to be delivered with a disregard for the Constitution and the Supreme Court precedents. Section 1821 of the 1999 Constitution of the Federal Republic of Nigeria clearly outlines the penalties for, that's where our concern is, forgery, regardless of the perpetrator's status. The tribunal also erred in failing to reevaluate the figures awarded to the PDP. It is a miscarriage of justice for the court to rule in favor of an individual who, as alleged, blatantly violated Section 1821 of the Constitution. It was erroneous for the court to assert that a petitioner must produce a certificate they did not create. Additionally, describing the evidence of witnesses summoned by the court as incompetent because the witness statements were not filed at the time the petition was initially submitted is a grave error. The Supreme Court, in the case of Agi versus PDP, defined forgery as presenting a document not created by the agency purported to have made it. In this petition that we are discussing, the tribunal called 5 witnesses, including a director from the National Youth Service responsible for call certification, and a managing partner of a law firm that sought NYSC certificate verification under the FOI Act to confirm the authenticity of Peter Mba's NYSC certificate presented to INEC. The tribunal's assertion that the forged certificate was not submitted to support Mba's qualification to contest the election contradicts the law and Supreme Court precedent. The tribunal's decision that the NYSC certificate is not a prerequisite for a gubernatorial election, or that both the forged and original documents must be presented to the court, is a gross miscarriage of justice. The court was incorrect in declaring that the NYSC certificate not having been mentioned in Form EC9, the affidavit of personal particulars, is merely an attached document and does not impact the qualification of the second respondent. Section 177 of the Constitution outlines the qualification for running in a gubernatorial election in Nigeria. Anyone eligible under Section 177 can be disqualified under Section 1821 if, as specified in subsection J, they present a forged certificate to INEC. The Supreme Court, in the case of Uche versus Onwe, 2011, all ALLFWLR, these are all technical terms. Maybe some of you that cover Judiciary will not understand what it means. 1227 at 1295, 2011, 4 NWLR, part 1237, and the rest of them that you will see in the paper we will give to you, of 1999 Constitution as a disqualifying factor. Tribunal findings that the NYSC certificate is not covered by Section 66(1) H of 1999 Constitution is absolutely incorrect. Hence, the judgment delivered by the Governorship Election Petition Tribunal in Enugu State can only be described as a gross miscarriage of justice and a fundamental jurisprudential flaw. And I want to repeat to some of you who may not have covered our first media conference where we told you that we actually filed a petition against that tribunal before NJC. I want to confirm to you also that we have a petition before the NJC questioning the credibility of that panel, particularly with regards to the chairman of that panel. Our key concerns. A central issue in the case revolves around the serious allegations of NYSC certificate forgery against Peter Mba, the PDP candidate. This allegation gains weight through NYSC testimony as contained in a sworn affidavit in the Federal High Court between Mr. Peter Mba and the NYSC, which form part of the evidence NYSC tendered before that court, that tribunal. The revelations from the issuing authority of that certificate, NYSC, is alleged to cast serious doubts on the authenticity of the NYSC certificate presented by Peter Mba, raising significant questions about the eligibility of the governor for the gubernatorial race ab initio. Again, The implications of the tribunal's judgments are deeply troubling. They undermine the integrity of the Nigerian certification process, not only for the NYSC, but also for other certifying bodies. The tribunal's decision, seemingly disregarding critical evidence presented by the NYSC, raises serious concern about the credibility of our institutions and the rule of law. On the one hand, there is confusion surrounding the appearance of the Department of State Security at the Enugu State Governorship Election Petition Tribunal. The question arises, why did the DSS appear at the tribunal? The DSS is not the issuing authority for the NYSC certificate, and they are not typically involved in NYSC matters. Their unexpected presence at the tribunal has raised concerns and cast doubt on their role because it falls outside their remit, their legal remit or their mandate. The DSS does not have a mandate to appear before election petition tribunals. It's unheard of. To appear in political cases and provide testimonies in favor of one candidate over another, especially when it involves a government institution like the NYSC. So the critical question that the journalists you have to ask is it possible that that witness who gave testimony on behalf of DSS was authorized, or was he procured as alleged? Furthermore, there is a troubling conspiracy theory yet to be verified unless thoroughly investigated by an independent body of experts to ascertain if there is a connection between the DSS hierarchy, as it were, and the PDP candidate, who is now the governor, the individual involved in the dispute with the Labour Party, the owner of the Pinnacle Oil, and his certificate issue, and the DSS even testified that it was valid, when in fact, the DSS is not the issuing authority of that certificate. Notably, there is the urgent need to further investigate why the DSS featured in that tribunal matter, which is unprecedented. Moreover, the individual, as reported by judicial reporters during the proceedings, whose name was identified as Isa Yahya Mohammed, that purportedly represented the DSS at the tribunal, is being alleged to be someone that is no longer in service. Mohammed had, at that tribunal, while giving a testimony, reportedly claimed that he was a serving deputy director in charge of operations at the DSS, and later contradicted himself in his written deposition, where he wrote that he was deputy director legal, strategy. However, it's essential to note that he appeared to have the blessing of the DSS, as they did not arrest him for falsely claiming to represent their organization. In typical situations, the DSS that we know very well would have swiftly apprehended someone who is claiming to be representing them. This has resulted in a situation where the DSS appears to have undermined their own institution and their own institution's credibility, and cast doubt in the NYSC's certification, integrity of the NYSC certification process. The larger question remains, what motivated the involvement of the DSS in this matter? Were financial incentives or other factors involved? There are various coincidences surrounding the strange appearance in a partisan political litigation by the DSS and the fact that they gave testimony regarding what is considered their secret internal investigative activity, assuming without conceding that the said individual represented the DSS. When in actual fact, there is absolute no need for the appearance, since the DSS is not an agency under Enugu State's chapter of the People's Democratic Party, which sponsored Mr. Peter Mba in that contentious gubernatorial election. HURIWA and patriotic defenders of national institutions, we are profoundly concerned that the NYSC, a pivotal institution in Nigeria, tasked with certifying the completion of national service for graduates, is facing questions about the authenticity of a gubernatorial candidate's NYSC certificate. This threatens the trust and credibility of NYSC certificates issued to all individuals. Here is the rule of law is a fundamental pillar of democracy. In this case, it appears that the tribunal's judgment may have departed from established legal principles. The rule of law guarantees that justice is administered impartially, without bias. We demand a thorough review of the judgments to ensure the rule of law prevails. Moreover, the independence of the judiciary is very crucial for the smooth functioning of a democratic society. This is where our own interest comes. As I had said repeatedly, we are neither for PDP or for Labour Party. The independence of the judiciary is crucial for the smooth functioning of a democratic society. A judiciary perceived as compromised or biased erodes public confidence in the judicial system. We call for an evaluation of the Justice Akano-led tribunal's decision to determine if it aligns with the principles of judicial independence. Already we have filed a petition before the NJC, as I had said earlier. The credibility of election is paramount for democracy to be sustained. The accusations of overvoting and bypassing of the beavers during the election in that contentious local government area in Kano East, as raised by the petitioner, demand comprehensive investigation to safeguard the integrity of the electoral process. Here are our stands and demands. In the light of the issues outlined above, HURIWA and patriotic defenders of national institutions firmly call for a thorough and impartial review of the Enugu State Governorship Election Petition Tribunal judgment to ensure that justice is served. The evidence presented by the NYSC and the allegations of certificate forgery warrant a comprehensive re-examination of that case. Furthermore, we demand a nationwide investigation into the authenticity of the NYSC certificates issued to individuals holding public offices. The credibility of these certificates must be verified to maintain public trust and uphold certification integrity and standard. In addition, the rule of law must be upheld without exception. The tribunal's decision should align with established legal principles, and justice should be administered impartially. The judiciary must remain independent and free from bias. HURIWA and patriotic defenders of national institutions emphasize the need for a thorough investigation into the allegation of overvoting and beavers bypass during the election. Electoral integrity, as I had been repeatedly said, is of paramount importance. In conclusion, we remain resolute in our commitment to defending human rights, upholding the rule of law, and protecting the integrity of our democratic institutions. We will closely monitor developments in this case and continue to advocate for transparency, accountability, and justice in our democracy. I thank you for coming. As I had said initially, the summary of this matter is that the that particular case in the Enugu State Election Petition Tribunal is not just all about the partisan contest between two parties, but the concern of the CSO community, particularly our group, HURIWA, and an affiliate body, Patriotic Defenders of National Institutions. We are concerned about the attempt made in that judgment by the tribunal to undermine the integrity of certification process and standards in Nigeria. If you say, if a court had legally invited witnesses from institutions that are specifically responsible for issuing a certificate that is in contention, and a director in charge of certification in NYSC appears before the tribunal and gives accounts, claiming that the certificate that was tendered by the gentleman, the winner in the mind of INEC of that election, did tender a forged certificate. And the DSS, a total interloper, appeared in the same tribunal and also gave a narration of its investigative activity whereby they try to justify the validity of a certificate they never issued. There are other witnesses that were also summoned. The tribunal that took good enough time to listen to these witnesses from individuals that are directly involved in issuing the certificate in question. You now end up just throwing everything away and just saying, well, it's not a big deal. The certificate is not even required for somebody to be qualified to run for office. This is a blatant attempt at rubbishing the certification process in Nigeria. If nothing is done about this, of course, a lot of Nigerians, the younger ones that are looking up to some of us who are already elders, who are statesmen and women in the society, if nothing is done to correct this wrong impression of the tribunal, that it doesn't really matter whether you tender fake or valid certificate, insofar that that certificate that is being contended is not a primary requirement that qualifies you for that office. It is an indirect way of saying, of a court saying, we don't care whether you have fake certificate or not. That is not how a court should operate. A court must make a definitive finding. If a question is submitted before a competent court of law, it is the duty and the constitutional obligation of that court of law to give a definitive, unambiguous determination of the prayers formulated before the tribunal or the court. You don't throw away prayers that are submitted before you on a very whimsical kind of reason. You must reach a determination, either or. Either you validate it or you invalidate it. That is our contention. As I said before, I was supposed to bring copies, they're in the car, copies of some of the documents that were tendered in court in that tribunal by the institution that issued certificates, NYSC certificates to individuals who are qualified, went to the court and tendered evidence to show